Well, hello and welcome to the Disability Law Show. Back again for another week. John Scholes here, and Sivan Tumarkin can be found at disabilityrights.ca, disabilityrights.ca, or you can always phone Sivan and his team anytime for more information. Get that free consultation in there as well. You need the information, so don't hold back. That number, 1-855-821-5900, help at disabilityrights.ca. All right, we got a lot of stuff to cover in the next 30 minutes, so let's get at it. 3 things you need to know before applying for LTD, long-term disability. That's coming up a little later on. We'll get to some emails, possibly some phone calls. It's a mixed bag of information, but it's crucial over the next 30 minutes. So stay tuned, and appreciate your input if we get to one of your emails later on. Sivan, we always start off with the week that was. Pal, what's cooking on your end?
John, it's great to be here, and let me tell you about an interesting call that I had with a gentleman just from Northern Ontario. He called me. He's a 48-year-old mechanic. He's a father of 2 children under 10. About 2.5 years ago, he was skiing with them up north and had an accident, hurt his back. And since then, it's been a difficult injury. He has not fully recovered. He has chronic pain, and he also suffers from depression, partly because of the issue with the injury and partly because of family factors. He had to go off work. His doctor has been supporting him. He has a family doctor, a chronic pain doctor, even a psychotherapist that he goes to. And so he was on short-term disability, and there were no issues for him to get that. And he has that through his health benefits plan through work. And so then he transitions into long-term disability. And the reason he called me is because everything has been going well. He's been following treatments. He's been doing well, relatively speaking, still having depression, taking medications, going through rehab for his back. But he received a letter from his insurance company telling him that his benefits, his long-term disability benefits, will end this December.
Okay.
And the reason is because they're saying it's been 2 years. That's the 2-year mark. We do not believe that you are now disabled from performing any other occupation for which you're suited for. And so we're going to just end your benefits. That was pretty much the crux of the letter. That's the letter that I saw that he sent me. And he was under the impression that he only had long-term disability for those 2 years. That's what he got from that. Mind you, at the end of that letter, there was a paragraph that said that if you have any other documentation, if you want us to consider anything, go ahead and send that to us, and we will reconsider. We'll, consider that to be an appeal. Mm-hmm. And so he called me. He called me because his wife watches our show. And so I had a discussion with him, and I explained something which is something that I hear quite often with people who don't understand the way long-term disability works. And this is what's really crucial for people to understand, John, is that long-term disability, when you have a policy for long-term disability with an insurance company, any insurance company, for the first 2 years to get LTD, long-term disability benefits, you have to be disabled. You have to be unable to perform the essential tasks of your own occupation, So he's a mechanic, can't do the job of a mechanic. He satisfies that test. That's why he received LTD. Beyond the 2-year mark, under most long-term disability policies, and again, we have to look at the policy to ascertain if that's in fact the case, but in his case, that is the case, the test changes. It's not that he's not entitled to long-term disability beyond 2 years. It's that the test now is, can you perform the essential tasks of any occupation for which you're suited by training, education, or experience? This is really key to understand, because if you're not suited to a certain position that the insurance company says you should try, well, then you don't have to try that position because you're not suited for it, okay? In his case, when I reviewed the medical documentation from the doctor, from the family doctor, the chronic pain specialist, and psychotherapist, and they all wrote reports to the insurance company saying he's still unable to work, period. Not so much because of the back injury, but now because of the depression that has taken over his life. And they said he cannot perform any other occupation. And yet the insurance company took the position that they're going to cut them off. And so I explained to him that, in my opinion, based on the review of the documents that I've seen, he absolutely would qualify for long-term disability beyond the 2-year mark. But the insurance company oftentimes takes the position that, no, the benefits end at the 2-year mark. And why do they do that? They do that because they're trying to wean people off these policies. And the problem is, when you have a gentleman like this person here who is legitimately trying to get better, who is disabled, who's unable to actually work at this point, maybe he'll be able to get back into it in a year, 2 years, however long the doctors think. But at this point, he's not able to get back to work, to any kind of work. The insurance company is not allowed to cut off his benefits. And so I explained that to him, and I told him, we can resolve this very quickly with the insurance company. They're not going to listen to you. You can try and appeal the decision. I've seen this many, many times. You appeal these cutoff letters, these cutoff decisions, and it goes nowhere. They just drag out the process, they stop paying you, you become more anxious, you become more depressed, you are more cash strapped, and you don't know what to do, and you may even miss the deadline to force them legally to pay you. And so I tell people, just give me a call. It costs nothing to speak with me, just like with this gentleman, and we'll be able to help them.
So if that's the case, how long, if they have not done it already, how long until this disability insurer says, well, go see one of our people. We'll fix this. You go see our doctor, and we're going to make sure that you go back to work.
Well, what's interesting is in this case, they haven't actually done that. In many cases, they do it. In many cases, they tell people, we're going to send you either to an independent assessment. Yep. I love that, by the way, independent assessment. Meanwhile, it's a doctor they're paying to assess you, to crank out a report that's favorable to the insurance company. But what you're talking about, John, is potentially going to a clinic or doctors that will treat you on behalf of the insurance company. And look, I tell people, if the insurance company wants you to see one of their doctors or go to one of their clinics for treatments, if you already have someone that's treating you for the exact same things that they want you to see one of their doctors or clinics for, you're under no obligation to go to their doctors or their clinic. Absolutely. Okay. Unless the policy specifically states that you must see somebody that they tell you to see, and I've yet to see this in a policy, unless they say that, unless the policy actually says that, not the adjuster, the policy, unless it's in black and white on the policy, you don't have to do it. But again, you have any questions about this? This happens. Even if you're not cut off, I tell people, John, you're not cut off, you have a question, you have a concern about your claim or about a family member's long-term disability claim or short-term disability, or anybody, give us a call or email us. It costs nothing to talk to us. We'll explain to you your rights. We'll explain to you what the insurance company can and cannot do. And we'll just blow out these myths, that people think that they have no choices. When the insurance company says jump, you have to jump. No, you don't.
The part you said about the second stage for anything with training, education, and experience, how far generally would an insurance company go? Because say someone's in a construction business, oh, that's okay, you can't lift 100 pounds or 50 pounds, but you could sit behind a desk and do computer work. Well, they were never trained for that. I mean, how far off the mark will they go to get somebody back to work?
So that's an excellent question. Sometimes they do assessments to try and figure out the kind of jobs or occupations you may be able to do with your experience. But I find that most of these reports are bogus. Why? Let's say, you have this gentleman who called me, he's 48 years old, has worked for about 25 years or so as a mechanic. He took some computer courses in high school, okay, like most of us. Yeah. But that doesn't mean that he can now compete with people in the field, that he can now go do programming, that he can now do whatever it is.
Coding and everything else.
Yeah, it's nonsense. But the insurance company is going to tell you, hey, if you don't try, you never know. That's nonsense. The insurance company cannot force you to go into an occupation or even try an occupation that you do not have adequate training, experience, or education in. Mm-hmm. And, to understand the granular aspects of it, because it's a good question you're asking, if you're a mechanic, if you're an engineer, if you're whatever it is that you do, the insurance company said, here are 5 different occupations I can try or I should try, and if I don't try them, my benefits are going to get cut off. Well, if you have training, education, or experience in that field. And if the insurance company is trying to force you into those occupations and you know that you can't compete, you can't get into those, you don't have to do it. No. You don't have to do it. But it has to be handled in an appropriate way. The response has to be crafted to the insurance company correctly to try and make them understand that if they cut off your benefits, they're going to pay for it big time. Again, that's where we come in. Because most people out there, John, don't know how to deal with these insurance companies. Right? The insurance company, the adjuster is telling you, you got to do X, you assume you have to do X. No. The insurance company has certain rights and obligations under the contract of insurance, under your policy, your LTD policy. They cannot go outside of that. They often do. That's where we come in to protect you because we know the law. We go head to head with them, and oftentimes, they back down very quickly. Because remember, these are adjusters. We are disability lawyers. This is what we do. We deal with this on the legal front. And we know what they don't know, and we also, when we comb through the file and look through, all the mistakes they've made, they often back up very, very quickly.
Handy website available to you as well called pocketdisabilitylawyer.ca. Pocketdisabilitylawyer.ca. Tell me about it briefly.
Pocketdisabilitylawyer.ca is a website we created a while back. It's been used tremendously, quite a lot, across the country. Essentially, there are people out there, John, who don't want to call a lawyer, who don't want to email a lawyer for whatever reason. We're human beings. We try to Google our answers. The problem is that if you Google your question, you're going to get hits from Google, but Google doesn't understand or know necessarily what's relevant with respect to your specific issue. So you may get advice that's applicable to a different province, or maybe advice that's applicable in the States, not here. Maybe even a website of someone who says they have to practice disability law, but don't really actually practice the way we do. And so we created this website, which is anonymous, which is free, takes a few seconds to operate. If you have any questions about your short-term or long-term disability case or issue, go onto it, get the answers you want quickly, efficiently. It doesn't send us any information unless you want to get in touch with us after. But it gives you accurate answers quickly, freely, and anonymously.
Let's get on to an email. First one of the show, first one of the half hour, help@disabilityrights.ca. That is the email address. Anytime. Says Mallory, I was recently told to take substantial time off work due to rheumatoid arthritis and fibromyalgia. I've been on multiple medications for over 10 years and experienced severe flare-ups that leave me unable to walk or concentrate. Despite this, I was denied LTD and told that I could work for years with this diagnosis, so I'm not considered, you love this one, totally disabled. There it is again. What can I do? Sivan, what do you think?
This is something, unfortunately, that's very common, and Mallory is not unique in this, unfortunately. Let me break this down. This term, totally disabled, or you have to be totally disabled to be able to qualify for long-term disability, it's true. That is what long-term term policies contain as the test for you to qualify and receive long-term disability. But when you hear the term total disability, the word total, John, it confuses people. Why does it confuse? Because when I say total, to you and I, this means 100%, completely. I totaled my car, means my car is is done, that's it, right? Yeah. I totaled my leg, my leg, that's it. Maybe it needs to be amputated now. Yeah. That's not what this means in the context of long-term disability. Total disability only means, and again, this is in the context of long-term disability, that you cannot perform the essential tasks of your own occupation, or any occupation if you're beyond that 2-year mark. I always give this example, John, because it's a really key example. Imagine you have a concert violinist or pianist or orthopedic surgeon, whoever it is you want that needs their hands. It's crucial. And they hurt their pinky finger playing squash, and now they can't operate, or they can't play the violin, or they can't play the piano. They can go to the gym and do weights. They can take their kids from school. They can go shopping. But guess what? Under the LTD policy that they may have, they are totally disabled from performing the essential tasks of their occupation because they can't operate, they can't do it. So my point is, in this case with Mallory here, rheumatoid arthritis, which can be very debilitating depending on how progressed it is, fibromyalgia, which is, I can tell you as a fact, can be extremely debilitating. I don't care what insurance companies say. I have chronic pain doctor friends who will tell you this stuff can get you in bed and you can have days where you feel like you just want to die. Yeah. For the insurance company to go against what this person's doctors say, that he cannot work at the present time, and to say you're not totally disabled is nonsense. So what are the options? The options are really quite simple. If we get involved, if you get us into the picture, and all you got to do is just give us a call, email us, speak with me, a member of my team, for free, absolutely for free. We'll explain to you the legal options. Legal options are not scary. It's not like what you see on TV. You're not going to court. There's none of that. It's us engaging with the insurance company. It's us potentially starting a legal claim against the insurance company. It's the insurance company then getting a lawyer like myself on the other side who's going to explain in simple words to the adjuster handling your matter that they have to pay. And if they don't, and they maintain that stupid position, at some point a judge will force them to pay. So again, I want people to understand they have a lot more power than they think, John. This is something that people are often afraid of, don't understand. Insurance companies can't just throw a term at you like totally disabled and say, you're not totally disabled. But I can't work. Well, if you can't work and your doctors back that up, you are totally disabled under the LTD policy, and you should get benefits.
Lots more to go here. We'll take a short break. 3 things you need to know before applying for LTD. That is on the way on the Disability Law Show, so stick around. We are coming right back.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. Employmentlawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to the Disability Law Show. John Scholes, Sivan Tumarkin, available at disabilityrights.ca. Make that phone call. That won't cost you a thing to call Sivan or a member of his team and have a chat. Get some information. 1-855-821-5900. Help at disabilityrights.ca. Always a main topic on the show. This week, another big one. 3 things, Sivan, you need to know before applying for LTD. Right into number 1, your treating doctor's support is absolutely critical. What do you think?
It is critical because insurance companies, in fairness to them, need to understand from your doctors what the issue is and how it limits you and the fact that they're supporting you being off work. And if they don't have that, they're going to ask for that. They're going to question you. And if you think about it, the rationale is quite simple. I mean, anybody can say that they're disabled and try and collect a paycheck. But if your doctors, and by the way, maybe you don't have a doctor, maybe you're living in a place where, you know, you just don't have accessible medical help. You're in a rural area, you have only walking clinics, maybe you don't even have that. Anyone that is treating you, who supports you being off work, is better than nothing. And again, insurance companies need this, and under your policy of insurance, it stipulates that you need to provide that to the insurance company. So, you know, before you even think about applying for long-term disability, if you have a doctor, if you have a psychiatrist, psychologist, chronic pain doctor, whoever you have that's treating you, get them, make sure, don't get them, but make sure that if you apply for long-term disability, that they are on your side, that they agree that you need to be off work for an indeterminate period of time until you get better.
The second point kind of rolls off of that, Sivan, that is you must follow appropriate medical treatment once you're in there.
And this is key, John. I have a friend who has recently been approved for long-term disability, and he's undergoing certain treatments for a heart condition and a few other types of issues that he's experiencing, which are preventing him from working. And what's happening in that case, the reason he called me is because he says, look, the insurance company is suggesting that I also do another type of treatment. Doesn't matter what that treatment is. My point is that it's not a treatment that he has tried. It's a treatment that sounds reasonable to me. I'm not a doctor, but it sounds reasonable. And I said to him, look, he's asking me, should I do it? And I said, well, first of all, consult with your doctors. If you do not do treatments which are reasonable, if you don't fulfill your obligations under the insurance policy, under the LTD policy, of trying to get better, the insurance company may argue that you're not mitigating, right? Mitigation is a legal argument, is a legal doctrine that says that you have an obligation to lessen your damages, to improve on your injury, for example, or your illness. And so you must follow appropriate medical treatments. Now, if the doctors are saying you should do X, but you can't, let's say, take these pills, but these pills are making you sick, well, have a conversation with your doctor about alternatives. It should not look to the insurance company as though you're not doing anything. You're just giving up. There has to be something that you're doing following medical advice, some effort.
Yeah. 3 things you need to know before applying for LTD. Number 3 is this: the insurance company may deny your claim for a number of reasons, like you illustrated off the top of the show, right?
Yeah, absolutely. So again, I want to make this clear, and I'm going to talk to the audience directly here. The insurance company will often deny your claim for any number of reasons, sometimes for 1 reason, sometimes for 2. I've seen as high as 12 reasons that they deny somebody disability. By the way, that case we resolved later on after them saying we're not paying for 12 reasons. We ended up getting this person over $300,000 from the insurance company. So the reason I'm saying they can deny your claim for any number of reasons, because they can come up with any reason. They can say you're not totally disabled, you're not following treatments, we have surveillance, we don't like your t-shirt, whatever it is. It can be a ridiculous reason. As long as you are disabled from working, you have a case. Now, can we go after the insurance company and force them to pay you despite the denial? Absolutely. Absolutely. We do this day in and day out. Myself, my team across the country. So while the insurance company may deny you for any reason, for any number of reasons, that's not the end of the story. You need to, as soon as you get that denial, even if you think you may get a denial, give us a call, email us, talk to me or a member of my team for free. I can't stress that enough.
I know.
It doesn't cost you anything to get this information and to empower yourself, and then we can tell you how we can help.
Lots more to go here. We'll take a short break. There's a website called mydisabilityquestions.com. That is where we're going to travel next for your next question. David, thank you in advance for that. As we continue more of the Disability Law Show, stick around.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back to the Disability Law Show. John Scholes, Sivan Tumarkin. Reach out anytime. As Sivan just mentioned before the break, there's no cost to that. 1-855-821-5900. Are encouraged to do so. Email help@disabilityrights.ca. And I did mention mydisabilityquestions.com. That is a website built for you to type in your questions. It's free, it's anonymous, it's searchable. That's the way the algorithm works. So maybe your question has been asked previously and answered thoroughly. It'll save you some time. If not, leave it there. It will get answered. From it, Dave, as mentioned, writes in, Sivan says, my mom worked as a clerk for years. Nearly 2 years ago, she had stopped working due to chronic back pain and migraines. With the support of her doctors, she's getting treatment for all her health issues, including anxiety. However, she suspects she's being followed during the week while doing errands. She's worried this will lead to her benefits being cut off. What can she do? The old surveillance, right?
The old surveillance.
Yep.
This is a common question, John. Look, it's normal for insurance companies to do surveillance in some circumstances. You know, when I used to work for insurance companies, approximately 20 years ago, I used to order surveillance on claimants where I thought that there was fraud, when I thought that they were not being truthful. And you know, the most powerful antidote to surveillance is be truthful.
Yeah.
Don't say something that is not true. Don't say that you're always walking with a cane, right? Because you can't walk without a cane. And then they catch you
doing
playing
burpees.
Soccer. Yeah, doing burpees. Going to. So, you know, you want to be truthful. You want to do everything that you're supposed to under the policy. Don't worry about the surveillance because you can't stop it. They can't interact with you, by the way. They can't, they can't speak with you, these people who do surveillance. They don't do surveillance for weeks and weeks. People tell me sometimes, I think I've been followed for several months. No. It costs more than $1,000 a day generally for them to do this surveillance. Insurance companies are cheap. They do not want to pay for that. But you know, to answer David's question, there's nothing really that you can do to stop the insurance company from doing surveillance. Just know and tell your mom to just keep doing what she's doing daily. She has the support of her doctors, so that's good. She's getting treatments, you know, for her condition, so that's good. And just to make sure that she's being very truthful with the doctors, with the insurance company. I have seen situations, John, where people do get denied or cut off benefits on the basis of surveillance. And I can tell you in the vast majority of those cases, when I've asked for the surveillance from the insurance company and they've produced it, it did not show anything like what they've described in the denial letter. And we called the insurance company on it in all these situations, and the insurance company did a mea culpa and reversed position and, of course, paid our clients. So the fact that you're cut off, if that happens, from surveillance is, again, not the end of the story. We want to see it. We force the insurance company to see it. They can't rely on it indefinitely if we get involved because they have to produce to us what they have.
Right.
So again, be truthful. I tell that to everybody, by the way, surveillance or no surveillance, be truthful. Because if you're not, lawyers like myself will find out. But if you're being truthful, the insurance company will not be able to stop you from getting the benefits owed to you.
I want to get to another email shortly, but based on what you just said about surveillance, they take it for a while. It's very costly. Aren't they going to want to squeeze something out of it regardless?
They sure can, but oftentimes it blows in their face.
Right.
I had a trial. I always say that these things never go to trial, or almost never go. But I did have a trial years back, and I remember there was extensive surveillance. and it was shown at trial. I thought for a second of asking the judge if we can have popcorn, actually. There was so much of it. And in the trial judgment, the judge actually made reference to the surveillance and in not so many words essentially said it was useless. In fact, if anything, it helped. Exactly. Yeah. So don't be coward. Don't be bullied by this idea of surveillance. Be truthful. If you are truthful, if you're telling your doctors the truth, if you're doing whatever you can to get back on track, to get yourself better, if you're being truthful with the insurance company, you have nothing to worry about. And if there is an issue, you give us a call at any point. Again, it doesn't cost anything to speak to me or a member of my team.
Did you get the popcorn?
No.
Don't like that judge. The judge is out. Okay, email. Martin's up next. Again, it's help@disabilityrights.ca. Says, I've been getting disability insurance for over a year now due to a shoulder injury that will probably need surgery. It's been an issue for over a decade, but has gotten progressively worse. My insurer is now pressuring me to apply for CPP disability benefits. Can I just ignore them?
You can. The problem is what they'll do is they'll likely guesstimate what it is that you're entitled to from CPP disability, and then they will reduce your long-term disability payments by that amount. And I tell people, John, you should apply for CPP disability if you are on LTD, because the reality is that even if you get accepted to CPP disability, and then the insurance company reduces your monthly LTD amount by the CPP disability amount, right? You don't get one on top of the other. It does strengthen your claim, and it doesn't insulate you from the insurance company cutting you off benefits, but it makes it that much harder for them because the government has now deemed you to be disabled for the purposes of CPP disability. And arguably, in my opinion, CPPD is actually harder to get than LTD. So if the government says you're disabled, who's the insurance company to tell you that you're not?
Right.
So Martin, my advice is apply for CPP disability. We actually have a very good free memo on this on one of our websites, LTDFAQ.ca. There's a memo there, I think 2 or 3 pages, explains CPP disability, pros and cons. I always tell people apply for it. If you get rejected, if you don't get approved, you haven't lost anything by it. We can actually help you with that, by the way, but regardless, you've done what the insurance company has asked you to do.
And if you do get denied for CPP, now they can't take that amount off and say,
no.
Well, if you would have got approved, we'd take 50. No, they can't touch it, right?
Yeah. You're asking, can the LTD insurer say, oh, you ought to have gotten approved, so we're going to reduce your LTD amount in any ways. Yeah. They can't do it. And if they do it, it's illegal. And if they do it, we can fight back and we can force them to undo it.
You've often said as well, the CPP is often a tougher test. Therefore, as to your point, it bolsters your claim. If they say I'm disabled, how dare you say I'm not, right?
Exactly, which is why I'm saying that I would tell somebody to apply for CPP disability if they are also on long-term disability. In my view, again, you lose very little, if anything, by that. You only have something to gain. And
if you get cut off, you still got CPP paying some bills, right?
Yes.
And people worry that's taxable, but there's a CPP tax credit as well.
Disability tax credit, exactly.
So there's really no way to lose if you apply for CPP.
There isn't. And you know, some of this stuff, again, is very confusing, and I understand that completely, which is why I tell people, call us or email us or go to one of our websites, which you're referencing. And you know, that website, LTDFAQ.ca, every time we have a topic where we have a lot of questions about appeals, surveillance, CPP disability, how should doctors write letters in support, we always tell them, go to this website, because we've done these memos, these short memos in plain English for people to just read up. And it answers the most common questions. Really, really powerful tool. But again, I keep stressing it because it's true. Give us a call, email us. It's free to talk to any one of us for as long as you need, and we'll answer all your questions, and you will feel empowered.
You got good information there to send you off until the next show, but in the meantime, do exactly what Sivan says. For you or a colleague or family member, make that phone call. Won't cost you a dime, right? 1-855-821-5900. The email address we always go to, help@disabilityrights.ca, LTDFAQ.ca, by the way, and then mydisabilityquestions.com. That's free, that's anonymous, that's searchable. Got you covered on all the angles. Thank you for your emails and everything else, and we'll catch you next week right here on the Disability Law Show. Thanks for tuning in.